Chapter 15 Law and Indian Judiciary. Rules and laws are necessary for proper functioning of system. Laws. Laws refer to such mandatory rules formed by the government which supervise the behavior and working of individuals in a society. Punishment is given in case of violation of law. To prevent from violation of law, it is essential for us to have proper information about it. We should necessarily follow laws because they are formed for our benefit. Laws are applicable upon all the people in a similar way. Our law does not discriminate with anyone on the basis of religion, caste or gender. Types of laws. Social laws. Laws based upon traditions, conventions and customs, and religious beliefs. National laws. Laws are formed by the legislature, like our Parliament, the Parliament of England, or Congress of America forms such laws. Laws are national as well as international. International laws govern the mutual relationship between two respective nations. Sources of laws. Indian Penal Code was formed to determine the process of punishment in case of violation of laws. The government formed Protection of Women from Domestic Violence Act to protect women against violence. The government formed Instant Law to suspend terrorist activities. Our judiciary. In our country, for the purpose of interpretation of laws and to provide justice according to the Constitution, an independent and impartial judiciary has been established. We know that there are three organs of the government: legislative, executive, and judiciary. Structure of judiciary in India. Local and district courts exist at the lowest level. High Court exists at state level, and in some states in a joint form. On the topmost level, there is the Supreme or highest court. Supreme Court. It has the right of interpretation of Constitution. It protects the fundamental rights of citizens. It is above all the other courts of the country, and therefore is also called the last court of appeal. The President of India appoints the Chief Justice of Supreme Court. With the advice of Chief Justice, the President of India appoints other judges. Jurisdiction of Supreme Court. Original jurisdiction. Article 131. Conflict associated with fundamental rights of the citizens between centre and the states, and hearing of conflicts between the state governments come under original jurisdiction of the Supreme Court. Appellate jurisdiction. Articles 132 to 136. Appeals against the decisions of High Courts can be done in the Supreme Court, and these cases can be of the constitutional type associated with the interpretation of Constitution, stands pending, or civil cases like those associated with land and property, purchase of commodities, marriage, divorce, rent, pact, etc., or criminal cases like those associated with theft, crime, murder, robbery, thrashing, etc. Protector of the Constitution and fundamental rights. Any such law formed by the government which is against constitutional provisions can be declared as illegal by the Supreme Court. This is also called as judicial review. In case of violation of fundamental rights of the citizens, the Supreme Court protects them. Supreme Court is also a court of records. All its decisions are published. These decisions are used as laws in the cases which follow.